The state's highest court concluded oral arguments this afternoon that could determine what car owners in Michigan pay for insurance and the care some accident victims receive. The case concerns Michigan's 2019 auto no-fault reforms, which supporters applaud for cutting costs of insurance. But thousands of accident victims who need lifelong care now have to pay medical bills. They say they should be covered. Which way it goes will now be up to the Michigan Supreme Court after a series of lower courts handed down dueling rulings. 13 on your side's Charlie Tinker joining us now with all the details. And Charlie, there's a lot to unpack here.
Yeah, Kurt, that's absolutely right. You got these four-year-old reforms that were passed by the state legislature to lower auto insurance costs, then the price caps that were introduced as an amendment later on to limit the amount patients receive for their care, which was covered before these reforms. And then you have the legal framework that is slowly but surely emerging. These court rulings effectively are building up all around all of that. And that's fluid, with a lot of ears on what was said, of course, during the hour today's hearing took up. Take a listen to this small sample as the defense laid out its case.
The caps are substantially more generous than we see under any other applicable system. They're more favorable than Medicare, Medicaid, workers' comp, and even private insurance. And it was working. We saw rates coming down, and we saw the driving public receiving a $400 per vehicle refund.
Now, you remember the courts did originally side with the reform crowd until an appeal found in favor of the folks who brought the lawsuit, victims injured before the update was signed who need round-the-clock care. But since the reforms cut payouts and reimbursements for that family, provided attendant care, and imposed caps on other coverage, they say it's not a change for the better, and in fact not one supported in law. They're arguing this goes against the state constitution, a violation of that contracts clause, and the state cannot move the goalposts or apply the change to victims injured before that. The Supreme Court now could rule along several different lines. We'll lay those out for you. They could reverse the lower court's decision on the basis of that contract question, or agree or affirm that ruling. That would mean broader ripples across the insurance industry, the healthcare industry, and you and I just on the road. We'll, of course, continue to follow this with what we're hearing from the plaintiff's side at 6. Though I should say it's not clear just yet when we might expect to have a decision, Juliette.
Lots of information. Thank you, Charlie.